I have a hearing tomorrow, and a hearing is a phrase, a language, a descriptive term that some courts use for what really is a trial. It's a trial before a judge only, without a jury. So the judge is the trier of fact, sort of like a Judge Judy or the People's Court, but with real serious rules of evidence. So how to conduct direct examination, cross-examination, how to enter evidence into the record with official rules and regulations. So I have a hearing, and the concern from my client is that there are false allegations made by the other side. So what can you do about that? Well, this becomes a one person's word against another person's word when and where there's no evidence to contradict. So if you don't have, these are not the facts in the case, but if the allegation is this person pushed me and there's no witnesses, there's just two people there, and there's no surveillance cameras, and there's no video recording, and there's no injuries, well, it's one person's word against the other. They have to swear or affirm to tell the truth. And then the trier of fact, the judge, has to determine whether or not the person that's giving that testimony is credible. They had to write it down, they had to swear to it, and then they have to testify in open court about those facts. And then they have to know, well, so that's direct testimony. Then the law permits it, you can confront your witness and you can cross-examine that witness. Now, if a person is resolute in their lie, if in fact they lied, well, we're not talking about any shocking revelations. You're right, I did it, I didn't do it, it's a lie. Very rarely do people that want to perpetrate a lie, very rarely do they back down. Sometimes it happens. Sometimes they decide not to go forward, right? But if a person does go forward, well, how do you combat that? Cross-examination. Is the person credible by appearance, demeanor, what they say, how they say it, what they explain? That's what you do.